The Director of Operations for the Pennsylvania Office of Open Records
Is the,
and he'll be presenting today. It's commonly referred to as OOR, where he oversees outreach and functions as the Right to Know officer. In addition to processing almost 2,500 appeals, the OOR office responds to more than 700 Right to Know requests in the year 2013. George has over 30 years of experience in state government operations, primarily in human resources. He and his family live in Lewisberry, York County. So George, the mic is yours. Thank you.
Thank you. Good morning. Can anyone hear me with the lapel mic? Are we okay? I'm fine. You're fine? Good. Okay, I'll just use this. Thank you. We're all set. Thank you. I'll stand over here next to the computer so we can do this. As was announced, the Office of Open Records handles roughly 2,500 right-to-know appeals a year. These are not right-to-know requests. Right-to-know requests, we handle 700 a year, just our office. Appeals are when a person is requesting records from an agency and they're denied. And then they come up to the appeal level where they're reviewed by attorneys. They apply law as it relates to the right-to-know law in various court cases and then render a decision. That's just more or less to give you a little bit of background as to what our office is responsible for. I'm assuming that most of you are open records officers or somehow associated with right-to-know requests at the local level. We only have an hour, so I'm going to cut out all the fluff and hopefully just focus on the facts. If something is said and you have a question, let's just jump right in. If it looks like it's going to get, detailed or complicated, we can take it offline, and I'll be happy to hang around after the session and answer as many questions as we need to. But basically, my goal here is to educate or refresh you on what you need to know as open records officers at the local level. And if you have questions as to what happens, beyond that, I'm happy to talk about that as well. But this is going to be my focus this afternoon. Like I said, and was introduced here, I'm the right-to-know officer for the Office of Open Records. And you'd be amazed at the questions we get. I mean, people think we're Google. They think that we have a big warehouse just filled with paper where we can answer just about any question that they have. I had to laugh a little bit as I was coming up 220 past the exit for Ebensburg. I haven't been out this way probably in about 15 years. It's a beautiful drive, but a month ago, maybe 2 months ago, got an email from someone who she wrote as if she were elderly, if that makes any sense. But she apparently was a resident at the orphanage at Ebensburg before it became Ebensburg Center. And she wanted to know if it was still there. Now, I knew about Ebensburg Center, never knew anything about that there was an orphanage there beforehand. So normally we don't answer questions like that, but I don't know, it just piqued my interest. So I made a couple phone calls, got on the internet. Sure enough, there's a web page out there about the orphanage that existed at Ebensburg Center before the state took it over. Fascinating stuff that we get into sometimes. But people think that we can solve murders. I'm serious. I'm serious. People will ask us questions about murders in the area and whether we can get them records, police reports as to stuff that's happened. Finding old relatives or ancestors so that they can prove their ancestry and in some cases citizenship. Had one lady email us from Italy. She's an American citizen but wants to get dual citizenship. So she's asking us, about her ancestors, and all she has is a name, and maybe they came from Butler County back in the 1800s. I don't know. But it's really, the questions we get, I'm going to say 90% of them are misdirected because people, number one, they're not asking for records, they're asking questions. And more importantly, some of the stuff that, like I said, they just think we have a warehouse full of paper. let me get into a little bit about the law. And the only thing I'm going to focus on here for your benefit is that records are presumed to be public. Under the old law, the burden was on the requester to prove that you have a public record, I'd like to see it. And if the agency wanted to deny it, they could for any number of reasons. Under the new law, and new law, the law is 5 years old now, which is still new when you're talking about jurisprudence. But under the new law, the burden is now on the agency to show that for whatever reason the record either isn't public or it should not be divulged through the right to know process. So, the burden is on you. The burden is on us to show if there's something that we believe is sensitive for whatever reason. The right to know law applies to a number of entities, one of those being defined as local agencies, conservation districts, as far as I know, and as far as our case records show, are considered local entities. That's correct. Subdivisions of state government, even local governments, they can track their creation back to state administrative law. There are some gray areas that we're getting into lately when you're talking about authorities, certain boards, certain commissions, et cetera, et cetera. That's something that our legal staff looks into periodically. Interestingly, just yesterday, we received 2 phone calls from individuals wanting to know whether or not the Right to Know law and the Sunshine Act, which focuses on open meetings, which is another area that our office administers, wanted to know if they applied to condominium associations. Does anyone here live in a condo and belong to a condo association? Yeah, you're probably lucky. They basically are elected boards that control, your life within that condominium complex. And in this case, they had, the board, at least in one instance, had voted they were going to replace all the concrete patios with wood. And it was going to cost everybody a couple $1,000s. And I guess this lady who's a tenant didn't like that, and she wanted to know if she could request records through Right to Know. Well, as it stands, the creation of condominium associations isn't governed by anything within state government, which can be good and bad, I suppose. But in her instance, we couldn't help her. So there is an entity with an elected governance that does not fall under the Right to Know law, just as an example. There are some interesting arrangements with private contractors. And the rule is does that contractor perform what's called a non-ancillary government function? Non-ancillary is a fancy way of saying, is it important? For instance, fire companies. That's an area that's still being sorted out in the law. But when you think about it, fire protection is a basic government function. And for the most part, there are some counties that are exempt, but for the most part, fire companies fall under the Right to Know law. Just as, I'm just throwing that out there as an example for your benefit. Okay, let's talk about agency obligations. Pretty basic stuff. You may promulgate your own regulations relative to how someone goes about filing a Right to Know request, but those regulations can in any way interfere with the spirit of the Right to Know request, or the Right to Know law, and public access to public records. So coming up with an example as to how that may apply, for instance, if you're an open records officer, you can require that the requests come directly to you so that they don't get lost in the bureaucracy or end up in somebody else's in-basket, sit there for a couple days while the clock is ticking. All right? Question?
The email that comes into my manager said in his email 4 or 5 days,
Mhm.
which was almost past the 5-day response time, till I received it. You wouldn't be in that situation.
Right. Well, it just so happens that there is a case before the Supreme Court relative to the interpretation of the right to know law as to who, or the basic question is, when does the clock start ticking? When I give the right to know request to the open records officer, which is what our office says, or when I, as a requester, hand it to anyone that's part of your organization, which is what happened in that case. The right to know request went to somebody who was out for a couple days. It sat in their inbox. We said the clock started ticking as soon as it hit that inbox. They're saying the clock didn't start ticking until it got to the open records officer. We're still waiting for a court decision on that. But the bottom line is, play it safe. Everyone in your organization should receive some basic training. One of the points made, one of the most important points you can make is that if you receive a right to know request, get it to the right to know officer right away, the open records officer. Every employee within your organization should be aware of that, just to play it safe. Because these deadlines are important. The deadlines are written into the law. Good question. Websites. And I think this is important, that if your organization has a website under the right to know law, you're required to have information on there about your open records policy, who your open records officer is, how they can be contacted, and information about appeals, which means you should have information about our office, the Office of Open Records, on there. Here's a quick example. This is an email page where we sent out an email blast to all the open records officers that we have registered with our office, and these are all returned to sender, that they were undeliverable. So go back home to your agency, check out your website, and make sure the information on there is up to date, and make sure that the information you have sent to our office with registering your open records officer and the contact information is up to date as well. Because we send out information on training, on changes in the law, on recent court cases and so forth. And if we can't get a hold of you, obviously that's a problem for us. Imagine though, these are taken from your websites as well. So if your websites aren't accurate, the public is having trouble getting hold of you. Yes, sir.
Sometimes districts that are part of the county system, sometimes they're not.
Yeah.
In those situations where they are part of the county system, the county has a right to know officer. But there's also districts that have a right to know officer. Can they sign up for this as well?
You should ask, yes. You should, if you have a right to know officer as part of a sub-organization, that person should be registered as well. And ideally, they should be on the website, so that sometimes the public doesn't, they can't tell the difference between, okay, county business versus conservation business. But give them the benefit of the doubt by putting on your name and contact information for conservation district business. Usually someone steers them in the right direction. I mean, that's just good customer service. So bottom line, make sure your contact information is there, that it's accurate, that it's up to date. You'd be helping everybody out.
So, Terry, can we register on your website?
We have, on our website, there is an email account specifically for local agency and state agency open records officers, where you can shoot us an email to that account, and it gets, our master list gets updated. So we'd appreciate it if you'd take a look to do that. And that's just gives me an opportunity to get a plug-in for our website. It's very comprehensive and has just about anything you would want to know about the right to know law. Sometimes you got to dig down a little bit, but if you can't find it there, feel free to pick up the phone or shoot us an email and we'll try and help you out. Question back here.
Do you have to be an open records officer to sign up for that?
For the registration, yeah, because what happens is Like I said, we send out information that's pertinent to open records officers.
Well, see, a lot of districts contact me. I work for DEP in Harrisburg.
Mhm.
A lot of districts will call me if they have questions on right to know.
Okay, so you're some kind of a liaison role, I'd
Yeah,
say?
I work for the Conservation District Support Section. I
Mhm.
possibly get those emails.
Well, you know what? There's no legal obligation outside of the right to know law when it comes to appointing open records officers. You know, some townships feel that the open records officer needs to take an oath or something like that. That's not the case. So, you know what? If you want to like designate yourself as an open records officer for purposes of dissemination and helping other people, you know, I don't see that messing up the system in any way. I mean, there's not secret stuff here. It's just the opposite. You know, we're trying to get out as much public information as possible. So go ahead and send us your information. We'll get it in the database somehow. Okay? Good. Good. Okay. Continuing with agency obligations, like I said, we want to make sure that your open records officer contact information is out there. Also, there should be a form for requesting public records on your website or a link to it. Now, the way the law reads is that you can have your own as long as it covers all the important information, or a requester can use our form, which is what we call the uniform open records request form, which is, you know, just a basic form that's on our website. The only difference is that you must accept it. Now, I ran across this just a couple weeks ago where there was a requester requesting pretty much the same sort of document from a number of adjoining townships, and what she did was take the form from one township that had their letterhead at top and make copies and just kind of change where necessary. One township would not accept that form because it had another township's letterhead on top. You know, tell me if that's right or not. You know, the letter of the law says they don't have to, but, you know, all she ended up doing was going back, and I think in this case she had to file a right to know request to get the right to know form from the subject township. Yeah, can you believe that? So, you know, bang my head against the wall, you know, but this is what you run up against, you know, and it works both ways. It works both ways with how people get along with each other. But your form has to be out there. Okay, this is something that I want to cover real quick, but yet it's an important point. Under the Right to Know Act, a requester does not need to disclose the reason why they're requesting the records. That leads many people to believe that you, as an open records officer, cannot ask them why they need the record. That part is not accurate, but I'm going to caution you. Quite often, I will ask someone, what is it you're really looking for? Because sometimes they're not sure, or they don't know whether or not this information is really captured by our agency, or they're not sure if it's something that they should be looking elsewhere for. So we'll get a request, and sometimes, you know, people, you know, that they're not lawyers, but they think they once played a lawyer on TV, and it's hard to figure out what it is exactly that they're looking for, and it would be incorrect for me to attempt to shape their request for them. So quite often I may shoot them an email or pick up the phone and have a conversation, and the question very well could come up. What is it you're really looking for, and why? Why do you need this? Now, the law says I can't deny their request based on the reason, but there's nothing in there that says I can't help them based on the reason. And sometimes if I know why they're looking for a specific record, I can think, aha, now I know what they're looking for, and if I don't have the record, I can at least steer them in the right direction. Again, it comes back to good customer service. But I want to caution you with taking that strategy, because some people are intimidated, and you just got to kind of, you know, read their voice or the tone of their communications with you as to whether you think it would be appropriate to ask them that question. Like I said, the law says you can't deny it, but there's nothing in the law that says you can't ask. Is everyone clear on that? Are we good? Yes, ma'am.
Because I've often wondered, sometimes when people ask for like a nutrient management plan, which could be 100 pages,
Mm-hmm.
you know, I mean, trying to find out, do they really need everything?
Yeah, that's an excellent example.
We're gonna have to charge you for this?
Yep, that's an excellent example where what they may be asking for in your mind represents a document several hundred pages at significant cost and significant work for you. Whereas if you ask them, why do you need it? Maybe there's an abridged version, maybe there's a summary somewhere, or maybe there's some other document that would answer their questions for them, that would save you a lot of work and it would save them a lot of money and time going through that big document. Okay, good example, thank you. All right, what's covered by the right to know law? Well, open records. And a record is a piece of paper, a record could be an email, a record could be a text message, anything that represents communication between parties related to the business of that local agency. Now, there are court decisions that deal with such things as emails and so forth that narrow it down. I mean, it's not any and all. But for the most part, you should assume that a record is public and open for public disclosure unless it's considered what's called a protected document. And when we talk about protected, it's protected by privilege, which is a fancy way of saying that maybe an attorney is involved with attorney-client privilege. Maybe a doctor is involved with doctor-patient privilege. Okay, those documents aren't even considered public. You know, they don't even enter into that realm because of their privileged status. But let's say it's not protected by privilege, then it becomes a public document, but it may still be protected by what's called an exemption. An exemption, within the right to know law, there's a list of 30 exemptions. I need to emphasize, and we'll get into this a little bit, the exemptions are reasons for you to withhold a document. For instance, anything related to a minor under 18 years of age can be withheld under right to know. However, the right to know law does not say you must withhold that. Police reports are a very good example, where under the right to know law, a police officer, police chief can withhold police records. But if that officer or chief considers it within the public interest to disclose that record, for instance, like a tape of a 911 call might be a good example. If they feel it's within the public interest to disclose that record, they have the option of doing so. Those exemptions that are in the right to know law are reasons as to why you can withhold it. They are not saying you must withhold those records. Now, let me throw a curve at you though. The right to know law assumes all records are public unless there is another law that says those same records are confidential. Therefore, the right to know law will defer to that other law. What am I talking about? Well, does anyone here have kids in college? Do you have kids that went through college? Okay. Did you run up against something called FERPA? The Family Education Rights and Privacy Act. You know, I have a son in college right now. He can hide his grades from me unless he signs off on a FERPA form that allows me to see his grades. Okay, now tell me that's fair. But under the right to know law, it's possible that his grades, even though he goes to a private school, let's just say he went to a public college. Under the right to know law, it's possible that his grades could be considered a public document. However, FERPA, a federal act, says no. His grades and anything related to his activities at college are private. And you know, he has to sign a form for me to see what I'm paying for, basically. So in that case, FERPA preempts the right to know law and takes precedent. There are other instances like that. Just the opposite. This one will get you. And I don't want to waste too much time on this because I know the last session of the day you folks are ready to go home. But there is an exemption that says autopsy records are not public in the Right to Know Act. But if you look at the State Coroners Act, it turns out autopsy records are public. And that all you have to do is go down to the coroner's office or the county office. You can pay for them and get them. So, you know, I think basically 5 years ago when they were writing the Right to Know Act, whoever wrote that particular exemption wasn't up on all the other laws and how they apply. But, you know, it works both ways. But the basic message is that there are 30 exemptions, which we'll cover very briefly, but they are not requirements. Okay, let's move on. Yeah, talking about what is a record. Audio, video recordings, maps, surveys, emails, text, instant messages. Never got into that, but they're out there. Audio and video recordings, you know, it's interesting how often we get appeals related or questions related to videotapes of security cameras. Sometimes it can be, you know, related to a potential crime where someone's kind of doing their own investigation, to whether or not you're showing up to work on time and they want to see the videotape from the security camera that covers the front entrance to know what time you report to work. It's pretty amazing, but this is what people, you know, they have a right to see this stuff if it doesn't represent a security risk. And, you know, it's kind of funny what they get into. It keeps us honest, though. Okay, who can make requests? Yeah, the term includes agencies, corporate entities, not just humans. The way the law reads is that you don't have to be a Pennsylvania citizen, you just have to be a citizen of the United States, or a resident of the United States, I think is the language in the law, that can submit a request to any local agency to request records. Interestingly enough, yes, sir?
Just noticing the guy videotaping in the back of the room here today. If we wanted a copy of that video, would we file a right to know request through you?
Not me, but I don't know who's the possessor of the video.
Okay.
You would request the record from the agency whom you believe is in possession of the record. If you were to request it from me, I would send you a denial saying I'm not in possession of that record, and if I'm a nice guy, I might make a couple phone calls to find out where the video ended up, and I'd tell you that in my response to you. And then I'd actually, in our case, we would actually put the contact information for the open records officer for the agency where we believe the tape is within their possession. Good example, good example. We do get questions occasionally from Canada. That girl from Italy, you know, she was an American citizen, but whether or not she was a resident or not, we answered a question for her anyway, which basically is, we don't know. But just keep that in mind, that it's residents of the United States. Agencies, meaning if, and this happens, if, for instance, one conservation district wants information from another conservation district, they can file a right to know request. And corporate entities, if I'm the president of a nonprofit group that has an interest in work that you may be doing, I can file a right to know request on behalf of my group, provided it's incorporated in some way. And we have standing before the courts, and as such, we have standings with the right to know law. Verbal requests. Someone can pick up the phone and say, I would like, under the Right to Know Act, to request certain documents within your possession. And you can verbally respond to that. The problem, however, is that the person filing a verbal request, for instance, if you end up denying their request, they can't appeal it. Because in order to appeal, you have to submit a written record of the transaction that took place. You know, these are the records I requested. and this is the denial that I got from the agency. Can't do that with a verbal request. Some people still do it. And that raises another quick point that I want to give you, since you're open records officers, is that you do not have to require that people use the Right to Know Act in order to request records. It's not mandatory. And a lot of times we will in fact encourage communication between the requester and the agency outside of the Right to Know Act in order to, again, good customer service. It might speed things up. The record that they're looking for is sitting right here on the desk. Hey, let me make you a copy. Pay me $25 and it's yours. And our business is done. No right to know request, no deadlines. Don't worry about appeal because right here it is. It's not a requirement. Interestingly enough, and I love picking on townships and boroughs, there are some townships where, and this, I'm going to say once a month I get this phone call. I was just appointed or I was just elected as a new township supervisor, and I wanted some information from my township manager, and he told me I needed to file a right to know request. Some townships operate that way. The only advantage I can come up with is that as open records officers, under the right to know law, you are legally protected so that if you give out something by mistake that maybe shouldn't have gone out, they can't turn around and sue you. No one can turn around and sue you because you gave something out in good faith under the protection of the right to know law that maybe you shouldn't have given out. Now, if you do that outside the right to know law, like I said, if someone just walks in and you think, oh yeah, here it is, take a look, and then you get in trouble, the right to know law can't protect you there because no right to know request was filed. Yes, sir.
Question, a lot of districts, they'll do, or entities, if there is a request from media, a paper, or
Yeah.
they request that they have a right to know, because if there is something that comes back from their board
Mm-hmm.
stating that they shouldn't give that information out, they have that document.
Yeah, yeah. And like I said, that's at your discretion, how you want to operate. I think one extreme would be those townships or boroughs or some instances school districts that require an officer of that local agency to file a right to know request to get information within their own agency versus something like a media request where because of, let's say there's just a lot of sensitivity over the issues, something's been in the headlines lately and it could blow up. Worst thing is seeing your picture on the front page of the paper the next day because you gave out information you shouldn't have. So like I said, the right to know law can protect you with legally as open records officers. And I think it's just a matter of using your good discretion since you're hopefully close to the issues at hand. Yes, ma'am.
Well, DEP is pushing us really hard to do everything as informal as verbals because it eliminates the appeal process. But then
I didn't know that. What's your name? No, that's okay.
and it opens us up for liability though.
Well, conceivably it does. However, like I said, with a verbal request, because it can't be appealed, it probably doesn't fall under the legal eye as closely as a written request outside of the right to know law would. I think in most cases, people are going to give you the benefit of the doubt unless something goes out that maybe was sensitive that you weren't aware of. Again, I think you're just going to have to use your discretion there. If you think that a person is coming in and verbally requesting a sensitive document that nevertheless you believe probably should be disclosed, first thing I would recommend is ask the person if they'd mind filing a right to know request, pick up the phone and either call a manager or at the very least an attorney that you may have access to. If it's a sensitive document and you're worried about potential legal ramifications, run it past your counsel and let them make that call.
Is that information between the department and the district, or are they requesting that you do that with people coming into your office?
Everything, even if we get a written right to know request, they ask us to go back and say, did you really mean it?
To the department?
To the
requester.
Oh,
and talk them down from that into a verbal request.
Okay, I would exercise caution with that. I think if that did end up being appealed in some way, and it did end up before a court, and let's say that records were still denied by the department, it could be construed as the department was no longer acting in good faith, and that throws your legal protection out the door. I mean, if you make an honest mistake, I mean, let's be honest, the law gives you the benefit of the doubt, but if you're operating under a procedure or under rules, and I'm not providing legal advice here, this is just me spouting off, but if you are operating under something that could be ultimately construed as less than forthright and outside of the spirit of the Right to Know Act, I think that ultimately a court could determine that you're no longer subject to the protection of that act. So I would be very careful with that. Slippery slope. Yes, sir.
Just a little more detail on that, at least the counsel I was given, is that ask if it could be informal, primarily because it relieves you of some of those timeline responsibilities. If they still insist on you, I mean, whatever, they get the document. But it just allows you a little flexibility.
Yeah. Again, I think you have to weigh good customer service versus what does the law intend and the protections that you're afforded as an open records officer, as well as the rights that the requester has. And if you are intentionally shaping his request in such a way to take away his appeal rights, I think you're going to find yourself getting in trouble eventually. So I would be very careful with that. Okay, let's move on. That's an excellent point, though. I appreciate that. All right, we're going to pass over that, except for this one point. A request must seek records, not ask questions. I don't know how many of you get that with your requests, but a person may come in and they want to know why the council voted a certain way. That's not a request for a record, that's a question, and therefore the request can be denied. However, if the person comes in and says, I would like a record of the meeting where the vote was taken, where they voted a certain way, and that record may include comments by the officers of that board or commission or whatever, that's a request for a record. Now, like I said, we get this all the time, and that's where you pick up the phone and say, are you looking for the minutes of that meeting? And the second they say, well, yeah, as long as it answers my question, then, you copy off the minutes, tell them it's going to cost them so much, and they can come in and pick them up, or you email them or whatever. Ideally, the minutes would be posted online, and you just say, hey, it's on our website, go take a look. Sufficiently specific, I'm just going to touch on this real quick. This is an area that we face all the time. Just yesterday, I was in a meeting where we were reviewing an appeal where the guy thought he was a lawyer, and he wrote out something that was so verbose that a room of 16 attorneys, we could not figure out what it was he was asking for. We looked at it, we tore it apart word for word, sentence for sentence, and still could not figure out what it was he was asking for. The local agency denied the request because they said it was it was not sufficiently specific. And I think the appeals officer is now probably going to agree with that agency and deny the appeal, because sometimes people, they just don't know what they're asking for, and you try and steer them in the right direction, but you get some folks who get a burr up their butt and they're fighting. That it's a very antagonistic relationship, and there's only so much you can do there. So I guess what I'm saying, there's only so much help you can give before you've got other work to do. So don't put yourself out too much with this. All right, receiving the request itself. Big thing is the request should come to you as the open records officer. At our office, first thing we do, we slap a date stamp on it. You know, note the date that it was received, count out 5 days for when a response is due. Keep a copy of the request. We create a file, what we call a blue folder, for all our right to know requests that come to our office. And within the first 5 days, there has to be a response to that requester. Now, within the first 5 business days, now I am assuming everyone here, for normal purposes with their offices, works a 5-day work week. Okay, so 5 business days is Tuesday to Tuesday, Monday to Monday, or whatever. There are those offices, small townships, where maybe they have a part-time staff, they're only open 2 days a week. 5 business days for them is 2.5 weeks. Okay, keep that in mind. Their 5 business days. Now, during that initial 5-day period, you can invoke up to a 30-day extension. What you have to do is respond back to the requester within the first 5 days, and you have to give them a reason. That reason could be, we need to do a legal review as to whether we can actually hand out these documents, or we're short-staffed. It's going to take us longer than 5 days to go down to the archives, find your records, and get them back to you. Or we're not sure we have them. We need to look around a little bit. There, in fact, are 6 reasons listed within the Right to Know law that allow you to invoke that extension up to 30 days. Now, we often get the question, when is the deadline if I invoke a 30-day extension? Well, it's at the end of the 30 days, and the clock begins ticking when I invoke the extension. So if I wait till the 5th day and then send the requester my notice of a 30-day extension, the request is going to take 35 days. You understand that distinction?
Is that also 30 business days? Too?
No.
That was,
No. And that's a good point. Because it does not say business days, it's assumed to be calendar days. Where the law is silent, it's calendar days.
So if you would reply on day 2 of the 5-day clock, then your 30 days starts on that 3rd day, basically.
Yes. Yes, it does. Best thing to do is pull out a calendar and count it. And when you invoke the 30-day extension, put it on the notice to the person about the day you intend to respond, you know, or the day that you believe to be the accurate deadline for your 30-day extension. Because their appeal rights and the clock for them filing an appeal begins ticking the day after you either respond to them and they're not satisfied with your response, or you may not respond to them at all, which is what we call a deemed denial, and their right to appeal begins on the day after that deadline lapses. And they have 15 business days in which to file an appeal, but guess what? They're my business days, not their business days. Our office is open 5 days a week, unless, like last winter, we're closed for a snow day, which seemed to be, you know, at least once a week. But then it's 15 business days based on the calendar maintained by the Office of Open Records. Okay, any questions on deadlines? Here's just an example. This is the Uniform Right to Know request form. It gives 2 examples. We have a spot down at the bottom where you can use for keeping track of your dates, or our office, what we do is date stamp it and physically write in the due date. Yes?
I just received one the other day, and there's a new line.
Yeah, about third-party notification. Yeah. That actually was the result of an organization that is attempting to acquire, actually somewhat successfully, the home addresses of Commonwealth employees. And based on language in a court decision, we determined it was appropriate for any entity, in this case it was the State Employees Retirement System, to notify state employees when personal information is being requested. Now, that language can apply to other situations. Namely, if someone is requesting documents related to a contract that you may have with a private entity, and there's a chance that information within that contract may contain proprietary information that would, if it were disclosed, it would render that contractor at a competitive disadvantage. Secret stuff that they have, you know, and they don't want the public seeing it, but they're willing to give it to you because they have a contract with you. Well, a lot of times what happens is competitors will file a right-to-know request for a copy of the contract. Well, what that language does is basically it lets you know of your obligation to notify your contractor that you've received a request for information that's private as far as their firm is concerned, and that under the right-to-know law, and there's clauses in there, they can basically protest the disclosure of certain information going out to the public, and in this case, competitors, because it would render them at a competitive disadvantage if their proprietary information got out to the general public. Does that make sense? Okay, but what started it was the whole, what's called the PFERS case. PFERS meaning Pennsylvanians for Union Reform versus PSERS, Pennsylvania State Employees Retirement System, where those employees or those members of the retirement system who were subject to the request all received notice from the State Employees Retirement System that, hey, someone wants your home address, it's your personal information, you have a right to know it's being requested.
What's the third party's rights in that scenario?
In that scenario, it was incumbent upon the third party to show that they may have qualified for an exemption. In most cases, it was security related. For instance, someone may have a protection from abuse order against a former spouse or former girlfriend or boyfriend. And if they did, and if they could show that there was a clear and present threat to their personal safety, their names were withheld. They weren't given out. Unfortunately, the rest of us, our names and addresses were given out. But that's the law. There is only certain information that's considered private. All right.
Wait, I'm sorry.
It's okay.
In that situation, would you then notify, or would I then notify that third party that this information is being requested?
Yes.
All right, so then I could drag out that 5-day timeline.
Yeah, as a matter of fact, you have to, because under the Act, I think the third party has 10 days in which to respond. And it's all in the Right to Know Act. The Right to Know Act, it's on our website. You can link to it, print out a copy, and take a look at it, and the minutia details if you want. It's not that complicated, but this is stuff that I think you'll rarely encounter, but nevertheless it is in there. Oh boy. Okay, what you need to do, train your staff, let them know what the Right to Know law is all about, that you're the open records officer, and that if you receive a Right to Know request, get it to you as soon as possible. Have them scan it in and email it to you if they have to do that, whatever it takes. But the clock starts ticking when they receive a copy of it. It's also a good incentive for getting your records in order. We found that the Historical and Museum Commission is the state agency responsible for records management, and they actually have people who, they border on being librarians when it comes to organizing stuff. And our office recently, our office is, we've got a lot of stuff going on with transactions and right to know requests and those 2,500 appeals a year that we deal with. Very paper intensive. We brought in the Museum Commission and are in the process of establishing a records retention schedule meaning certain stuff we only hang on to for so long, then we toss it, or it gets moved to the State Records Center or the archives or whatever. But it's forcing us to get organized. We can find stuff much easier now based on their retention schedules. And if you have a retention schedule, say there's some document that you have on your retention schedule that after 5 years we shred that document or we throw it out, someone comes in and requests it, you can say, that document's over 5 years old, we no longer have possession of it. And remember, you're not responsible for providing a document that you're not in possession of. Now, am I advocating that you shred everything as soon as possible? No, but if there's not a good reason to have, and every office has that one guy where his office is just loaded with stacks of paper and boxes of stuff that should have been thrown out decades ago, all right? This is a good incentive to get that guy to go through all this stuff and clean his office out. Same way with your filing cabinets. You'd be amazed all the stuff we have in our offices that we really don't need, you know? Another thing that we're doing is we actually hired an intern for the summer who is going through all our files and scanning them, and everything's getting digitized. So if I want to find an appeal file, now I can go online and everything is scanned in and I can just look at it then. We're getting rid of those stacks of boxes that we've had since 2009 of old appeal folders. And it's really not costing us all that much to do. It really isn't. So I would encourage you to do that. But you can reach out to the Pennsylvania Historical Museum Commission. They provide very good training and a very good system for you to get your records organized. Okay, this is what we just talked about, the third party, so I'm going to skip over that. Yeah, basically, if you have a contract performing state business with a private contractor, it is possible that the records within their possession are considered public records. So under the right to know law, the request would come to you, but you're responsible for getting the records from that third-party contractor. Now, everything that contractor has, is it public? No. But what's related to their relationship with your entity, with your organization. For instance, I'll go back to fire companies. Most fire companies, volunteer fire companies, are privately incorporated entities. However, they perform a basic government service, keeping my home from burning down. And there is a relationship between the township and the local fire company. There is a legal document that basically says that fire company is going to provide protection for our government jurisdiction. Okay, so you could raise the argument that there are certain records within that fire company that are within the public domain. Do I want to know how much money they made at their chicken corn soup sale last month? It's not a public record. Do I want to know what their average response time is between the hours of 9 p.m. and 6 a.m.? Yeah, maybe that is within the public domain. So, you know, that just is I'm using that as an example.
So it doesn't have to be a record that has anything to do with you?
What do you, me as the requester?
No, with the agency that you're requesting from.
No, the record should reflect the relationship that the reason why that person is a contractor for you. So I don't know, do you have contractors that, I don't know, well, what do your contractors do? Do any of you have contractors? And what's an example of some of the work they provide?
We hire contractors to do street bank restoration.
Okay, so if you know, there's probably some sort of work plan that they have developed or a schedule that determines what work they're going to do when. That schedule might very well be within the public domain because it's state lands and they're doing work for the state. So I could file a request with your office for work being done by that contractor. And by rights, those records would be considered within the public domain. Okay, we talked about the deadlines. The response options are you can deny, and there may very well be a valid reason for denying the request. It may not be a public document, it may be protected by privilege, or it may fall within one of the 30 exemptions within the right to know law. So you can deny a request. You can ask for an extension like we talked about with the 30 days. There is language to go beyond the 30 days, but I don't want to get into that because it's going to take too much time. Or you can simply grant the request by providing the records that they've asked for. We talked about extensions, granting access. Let me just go over a couple quick things. You are only required to provide the record in the format that it exists within your possession. So that if someone comes in and they ask for a report and you only have it in hard copy, you're only required to provide it back to them in hard copy. Now, if you have a hard copy version and you have a scanned in version, and they come in and they say, I'd like it emailed to me, then you're required to email it to them because you have an electronic version. Where it gets a little dicey, let's say you have a spreadsheet and the person comes in and says, I don't want the PDF version of that spreadsheet. I want the Excel version of that spreadsheet so that I can manipulate it. And you're thinking, oh man, I'm not sure, that would, maybe we'd get some phony reports out there then where they've changed the numbers, and I'm not sure that's a good idea. Or maybe there's policy behind the formulas that are embedded in the spreadsheet that represents some sort of confidential information. I know that's a stretch the way I just said that, but it happens. It's true. You understand. You're going to have to take a really close look. Number one, do you maintain it in both formats? Number two, what's the risk of providing it in an Excel sheet? The way the law is now is that if you maintain it in Excel, you got to give it to them in Excel. There we're talking about not just the medium of the message, but the actual format within the medium. Run into this a lot with local townships and the use of QuickBooks and QuickBook reports, just as one example. You have a question, sir?
Yeah, could you lock the spreadsheet?
Conceivably, and yeah, that's what I would do. That's what I would do. There's a lot of people at the local level that aren't savvy, with Excel. They're not power users, but it's certainly an option available to them. Now, what will happen is the person will come around and say, give me an unlocked version of the Excel spreadsheet. Well, you just got to be careful and use some common sense there. But believe it or not, there are court decisions that have wrestled with this very issue. And there is language out there on our website as to how we regard this. Okay, well, class is extended for a couple minutes. Okay, fees, 25 cents a page for copies. You cannot charge for scanning. You cannot charge for your time. You cannot charge for redacting information, which is basically blacking out sensitive stuff if you have to do that. You can charge 25 cents a page for 8.5 by 11. If someone's coming in and asking for prints, and you have to run down to Kinko's or local architect's office to get copies made, you charge them for whatever it costs you to make those print copies. You cannot charge for emails. You can charge for CDs, $5 a CD. Just trying to think if there's anything else out there. But when in doubt, give us a call. We'll look it up and see if there's any way you can pass on some of your costs. But for the most part, 25 cents a page. Any questions on that? Oh, postage, I should mention that. Whatever it costs you, you pass on to the requester. It's always a good idea to let the requester know there's going to be a charge, and if you know what that charge is ahead of time, before you do a lot of work, pick up the phone and say, hey, this is going to cost you $35. I just wanted you to know. They may say, oh, I didn't realize that. Wait a minute. And that'll save you a lot of work. Then you just ask them to withdraw their request if they're not willing to pay. If you do all the work, tell them it's going to cost $35, it'll be here when you pick it up, and they never show up, your obligation, I think, is to hold on to that document for 30 days. Then you can destroy it. If you get another request from them, you can deny it outright because they owe you money. Okay? And you can tell them that. Hey, we'll grant your request as soon as you pay for the last one you didn't pay for. Disruptive requests, we always get this. There is a court decision that contains very specific language. If you have a person that keeps coming in and asking for the same thing, there's two things you have to keep in mind. You can deny that request after the second time, meaning you have to provide the same thing to them twice. The third time, you can say no, provided it's disruptive to your operations. Meaning, if it's no big deal for you to just go over and make a copy that third time, you're going to have to provide it. However, if you got to drop everything and spend a couple hours working on their request for the same thing they asked for last month, you can deny it because that's a disruption. Now, when I talk about the same thing, I'm talking about the exact same thing. Not the minutes from last month, the minutes from the month before, the minutes from the month before that. They're entitled to that, but they're not entitled to come in and ask for the same monthly minutes more than twice, especially if it's hard for you to get them together. Yeah, this is kind of what I said about discretion. The right to know law does not require you to withhold documents based on the language there. You have the discretion to release a document if you feel it's within the public interest to do so. And if you're releasing it in good faith and you end up getting in trouble, the right to know law will provide legal protection for you. The exemptions, I'm not going to go through them because there's 30 of them and some of them get really detailed. But for the most part, I think you'll find that there's common sense reasons as to why those exemptions exist. Redacting, like I said, you can release a record, but if there's sensitive information on there, like bank account numbers, social security numbers, private email addresses, private home phone numbers, you can black them out before you release them. It's known as redacting. And if you have to, let's say you take the original record, you can't redact that, but you need to make a copy of it, then you get your black marker out and redact the sensitive information, and you figure you better keep a copy of the redacted form, so you make a copy of that as well to make sure nothing shows through. That's 2 copies for the same form. You can charge 50 cents for that 1 page. All right? I just recommend that you explain it to the person, and if you understand the distinction there as to what I'm saying, in order to make sure that they can't like read through your marking, so you run it through the copier on extra dark, you can charge them 50 cents for doing that. Yeah, filing an appeal, I'm not going to get into that too much because you don't deal with appeals that much. But once a response is provided, or if you fail to respond within the deadlines to the requester, they have 15 business days in which to file an appeal. In most instances, that appeal is with our office, particularly if it's dealing with what you do in the conservation districts. There are other avenues of appeal, but one involves criminal records, one involves the legislature, another involves the courts. For purposes of conservation districts and state agencies, appeals come to our office. Now I want to tell you something. If an appeal is filed against a request that was with your conservation district, it's not the end of the world. Don't get all wigged out. Don't get worried. Like I said, we get 2,500 appeals a year, okay, from all kinds of sources. And it's pretty much, how does the law apply in this situation? Not, do we need to go out and beat up that open records officer in the conservation district for denying the request. That's not how it's viewed. When an appeal is filed, it immediately gets docketed by our office, and within 24 hours, notice goes out to both parties that an appeal has been filed and that you have 7 days in which to provide us with the necessary documentation for the appeals officer to review the case. And within a month, typically, they will issue what's called a final determination, which is a legal document, a legal decision that you can find them on our website, what they look like. But basically, an attorney, an appeals officer, is reviewing the appeal. He'll review the documents that are sent in from the local agency and the requester, apply the law, and determine what we believe is the right thing to do. And certain things can happen. They can turn around and grant the request and say, open records officer, you were wrong. You need to provide those records, and here's the legal reason why. They can say to the requester, Conservation District was right. Those are confidential documents, or they are protected by an exemption, or maybe your response was, we don't have those documents. And the requester says, I don't believe you. I'm filing this appeal. All the appeals officer does is go back to the agency and says, provide us what's called an attestation, which is essentially, it's a legal document where you say, I don't have the records. We're not in possession of them. And for most appeals officers, that's good enough. And he'll just reply back with his final determination that these are the documents the requester was seeking. In their initial response, they said they didn't have them. Requester filed a timely appeal. We have jurisdiction, yada, yada, yada. And during the appeal process, the Conservation District provided attestation that they are not in possession of the requested documents. And given the circumstances, everything makes sense, the appeal is denied. You'd be surprised how many of those we deal with. Like I said, it's not the end of the world. And if it turns around, the appeals officer issues a final determination that your legal counsel disagrees with, that requires you to grant documents, you have 30 days in which to go take us to court. And trust me, that happens. When I talk about these court decisions that provide language for what we do and how we apply the law, it's all the result of local agencies, state agencies, other entities, school districts, in some instances requesters taking us to task on our interpretation of the law. And in many cases, the courts provide the necessary guidance to establish legal precedent that we then apply from that day on as to what documents are considered open records and what documents are protected by the Right to Know Act as well. For the most part, that's it for open records officers. I hope I provided you with a good grounding. If any of you have specific questions or want clarification, I'm going to be here for a while, so feel free to have at it, and we can talk, and I'll try and explain as best I can. Check out our website. If you have any questions, pick up the phone, give us a call. We actually have human beings that answer our phones. Or you can shoot us an email, and we try and get back to you within 24 hours because we realize many of the questions that you're sending us are related to current requests that you have, and you need to reply.
Are you able to, if someone calls and says, I got a request for this type of document, are you able to give
We
them
will not
some
provide
guidance?
you legal advice over the phone, but we will tell you what we've done in similar situations.
So you can give some guidance?
We will give you guidance. We will not give you legal advice. Thank you very much.
Thank you.